got a little more space. If everyone is comfortable and settled, we can go ahead and get started. So my name is Tony Chadwick. I am the Open Records Counsel with the Comptroller's Office. This is Seth May. He is the Assistant General Counsel with the Comptroller's Office. And we're so excited to have so much attendance at our Jackson Fall Roadshow. So we'll go ahead and get started. Maybe. All right, so what we're going to talk about this morning is going to be all sorts of things that the Office of Open Records Counsel handles. So we're going to start out by telling you a little bit about our office and the benefits of contacting us, being in touch with us. And then we'll move into the Tennessee Public Records Act itself. We will probably refer to that quite a bit as the TPRA throughout the presentation. So when you hear us say TPRA, that's what we're talking about, the Public Records Act. We'll talk about some of the common exceptions to the TPRA. Then we'll move into processing public records requests, sort of the nuts and bolts of how to handle those requests when governmental entities receive them. Then we'll move into the Tennessee Open Meetings Act, or what we'll call TOMA, throughout the hearing or throughout the presentation. And we will take questions at the very end of the presentation just so that we can get through all of the information. A lot of times we see questions come up and then the answer is just a few slides down. So if you'll save your questions until the end, we will make plenty of time to answer all of those questions at the end of the presentation. We'll also try to identify some of the current issues and challenges that we're seeing with respect to public records requests, and that can be on both the governmental entity and the citizen side of things. So we'll work through some of those and try to give some information about how to handle those on either side. All right, so our office, the Office of Open Records Counsel, or OORC, was created in 2008. The General Assembly put us under the purview of the Comptroller's Office in creating the office. And our role is essentially to assist citizens and governmental entities better understand Tennessee's sunshine laws. So the TPRA and TOMA are the two major hallmarks of the sunshine laws, and our office helps to explain those issues, or explain any of the issues that may come up with those two essential laws under the Sunshine Open Records and Open Meetings Acts. We also do a lot of educational outreach. So presentations like this across the state. Every fall we do our roadshow where we travel across the state and do presentations to provide information about the TPRA and TOMA. We also develop forms, schedules, and policies for public record requests. Those are all listed throughout our website where you can find a lot of really beneficial information. And then we also respond to any kind of questions that we get from the media. So really, anybody who has a TPRA or TOMA question within the state of Tennessee, we're the contact for those questions, and we can provide answers as quickly as possible. One big thing to note here, though, is that we cannot enforce the TPRA or TOMA. We statutorily do not have enforcement authority. That is granted to the courts under both of those separate laws. Okay, so as I mentioned, our office does do a lot of development of forms, schedules, and policies. These are some of the policies and guidelines that are listed on our website. You'll find everything from best practices to the Model Public Records Act. There's also the Schedule of Reasonable Charges, which is a really important policy that we have there. Governmental entities can access that policy and adapt it themselves if they are interested in that. But the important thing with the Schedule of Reasonable Charges is that as long as a governmental entity is following what is listed throughout the Schedule of Reasonable Charges in charging citizens for public records requests, then they will always be found to be reasonable charges. So as long as they're in line with what our office has created in that Schedule of Reasonable Charges policy, then the charges are assumed reasonable. And it's an easier way for the governmental entity to explain why the charges are what they are. And if a citizen reaches out to us and complains about charges that they've received or that they've been told they will be charged for records, we can immediately look at the Schedule of Reasonable Charges, what the breakdown of the charges that are being charged to the citizen are, and then determine if it's in line with our Schedule of Reasonable Charges or not. The safe harbor policy is also a really important policy. So it's the idea that if a governmental entity is unsure about whether a record is open or confidential, and they reach out to our office, as long as they follow the advice that we give them in determining whether that's confidential or not, then the courts are a lot less we can never say what the courts are going to do, but they're a lot less likely to find that there was a willful denial, and therefore that the governmental entity should be charged attorney's fees, filing fees, and anything like that. So sometimes the court will say, actually, this record is open. The governmental entity should have turned it over, maybe subject to a lot of redactions, maybe open in its entirety. So you have to give it to the citizen. But as long as you follow our advice, the governmental entity is very unlikely to also be charged those attorney's fees, the filing fees, and anything else, which the TPRA does allow for if a governmental entity willfully withholds a record that they know is open. And I think the safe harbor policy, there's the flip side of the coin there too, where if you reach out to our office and we say that it's confidential and you hold on to that record, even if later the court says it should have been open, I always like to say you can't put the toothpaste back in the tube. So if you release a record that has some security vulnerabilities about a governmental building or something listed therein, and then later the court says, actually, that was probably not something that you should have released, it's out there. There's nothing you can do to get that information back. Okay, so some of the benefits of utilizing our office, most of them we've already been over. So that's whether a custodian may pay attorney's fees. That's our safe harbor policy. The schedule of reasonable charges, where the charges are presumed to be reasonable. And then Seth and I are both very familiar with records and meeting issues, but we're a neutral party. So we don't advocate on the side of the governmental entity or on the side of the citizen or the media. We get the questions and we provide the answer based on the law. We like to say that we are on the side of the law. So we're here to advocate for the proper following of the TPRA and TOMA itself, not for citizens or governmental entities, just what the TPRA or TOMA say. And we're free. So this is a screenshot of our website, and there is so much beneficial information there. I would really encourage anybody who's here is clearly interested in some way in the TPRA and TOMA. So visit our website, and under the reports, policies, and updates bar, you'll find a lot of really beneficial information. You'll even find a link to the TPRA and TOMA itself. Under resources is where you'll find frequently asked questions, informal advisory opinions, things like that. And there is a public-facing exception database on our website. So you can, from our website, access this exception database, exceptions being things under the TPRA that are confidential. If you have a question as a citizen, you've submitted a request for a public record to a governmental entity and they've denied that, you don't understand why it's been denied, you can go into that exception database, type in a few keywords, and see what pops up that may explain why the record request was denied. If you don't like searching for that information, or you still don't know why your request was denied, then you click the Submit an Inquiry box. That will bring up a form that you just fill out with your name, your contact information, and your question. And then that immediately feeds into a database that Seth and I work out of every day. So the first thing I do when I get to the office is pull up the database where people have submitted an inquiry, and then I check to see what new questions we've gotten and answer those throughout the day. As soon as we finish this presentation and get to our next stop, the first thing we'll do is pull up that database and see what questions we've gotten even this morning.
So now we're going to turn to the Tennessee Public Records Act itself, the TPR. Before we do that, I tend to mumble and I talk fast. At the back, can y'all hear me? Excellent. All right, is that better? Yeah. Perfect. If at any time I wander away from the mic or start talking too fast or whatever, just throw something at me or throw something at someone else. Get my attention somehow. The Tennessee Public Records Act is intended to be a symbol of transparency. The Tennessee Supreme Court said that facilitating access to governmental records promotes public awareness and knowledge of governmental actions and encourages governmental officials and agencies to remain accountable to the citizens of Tennessee. The motto of the Comptroller of the Treasury is to make government work better, and I think you could rephrase this quote as open government makes government work better. And that's why the Public Records Act and the Open Meetings Act are so important. So the heart of the Public Records Act, the TPRA, is found in Tennessee Code 10503, and just the most basic summation of the Public Records Act is that all public records are open for inspection by any citizen of the state unless they're not. So throughout this presentation, most of what we're going to address will fall into one of those four categories. Just as basic summation has its own, creates a really important presumption, and that's the presumption of openness. So when a custodian's looking at a public record, the first thing to think, is there a reason why this would not be disclosed? Is there a specific statutory exception, a specific exception to make this confidential or to redact this? If there's not, then it's an open record. The presumption is that something can be turned over. We're interpreted to interpret the Public Records Act. We're instructed to interpret the Public Records Act broadly. So that comes from the Public Records Act itself. At 107-505, courts are to interpret the provisions of the TPRA broadly to give the fullest possible public access to public records. And then our courts have reiterated that. The TPRA expresses a clear legislative mandate favoring disclosure of governmental records, and unless there is an express exemption within the law, disclosure is required even in the face of serious countervailing considerations. So if you're a custodian, you know that turning over information doesn't always feel good because it feels a little bit invasive. I know personally, I don't like the fact that the NES, the National Electric Service, is required to give out my personal information if it's requested, but there's not an express exemption for that, and so it's public. So before we get into the meat of the TPRA, we'll talk about who is subject to the TPRA. Generally speaking, it's governmental entities. So this is state governmental entities. State governmental entities are not subject to the Freedom of Information Act, that's a federal law, but every governmental entity in the state is subject to the Tennessee Public Records Act. So that is all your state agencies, the executive branch, the judicial branch, the legislative branch, all of your statewide boards, like the Tennessee Board of Utility Regulation that I sit as counsel for, and then also your county and local governmental bodies. Everyone is subject to the TPRA. The TPRA can also apply to the functional equivalent of a governmental entity. The functional equivalent is not just somebody who does business with the state. Our courts have been very careful to say that not every contractor for the state, not everyone who provides a service for the state is a functional equivalent of a governmental entity. The functional equivalent is someone whose relationship with the government is so extensive that the entity serves as the functional equivalent of a governmental agency. That's a legal test, and to look at that, you look at the level of government funding, the government involvement and control over the entity, and then whether it was created by a legislative act or whether it's previously been held to be subject to the Public Records Act. The burden is on a petitioner to show that a private entity is subject to the Public Records Act. And a good example of that would be a private prison. Running a prison is something that's traditionally delegated to the state. So when a private entity is operating a prison, they're acting as an arm of the state. And so in that respect, they're the functional equivalent of a governmental entity. So remember, all public records are open for inspection to any citizen of the state. That is, any Tennessee citizen. As part of that, governmental entities or records custodians are allowed to verify an individual's Tennessee citizenship. Most frequently, that's going to be a driver's license. It has to be a government-issued photo identification that shows that an individual lives in Tennessee. So that could also be an identification for identification only instead of a driver's license, or it could be a handgun carry permit. And custodians are encouraged to have alternative documents for people who can't produce a driver's license. So some custodians might accept a utility bill or a proof of property ownership as verification of citizenship. So neither of those, strictly speaking, verify citizenship, but custodians are welcome to accept that verification if they want. Whatever kind of verification they will accept, it's best if that's spelled out in the public records policy. And proof of citizenship in general is discretionary. Custodians are not required to verify citizenship prior to providing records. However, that should be done uniformly, and it should be reflected in the public records policy regardless. A couple of other implications here. It's our office's interpretation that this doesn't apply to artificial citizens. So businesses or nonprofits that are in the state, we don't consider them to be Tennessee citizens. So that means if a custodian gets a records request from Walmart submitted by John Smith on behalf of Walmart, they would not consider that to be a request from Walmart. They would consider that to be from John Smith, and the custodian should verify John Smith's Tennessee citizenship. If you go to federal law, there's this whole body of law about who is a citizen of what state for purposes of service of process, and we don't implicate any of that. We just say that artificial entities are not citizens of the state. It has to be done through a person, through an individual. We can also see this come up in the context of attorneys. You might have a Georgia attorney representing a Tennessee citizen or a Tennessee attorney representing a Georgia citizen. In that case, the governmental entity should verify the citizenship of whoever lives in Tennessee. That could be the attorney or the client. Either one should be fine. So now we'll talk about what is a public record. All public records are open to inspection by any citizen of the state unless they're not. A public record is any record made or received pursuant to law or ordinance, or made in connection with the transaction of official government business. That definition is lifted largely from the Public Records Act itself. So that does not include the actual device or equipment on which a record is created. It's only records that are created. It also does not include information. Information is not a record unless it's recorded to a medium somehow. If it's recorded to a digital recording, written down, typed out, that's a record. But just information is not a record. A public record includes drafts of records. So a city's draft budget or the draft minutes of a meeting, those are still public records even if they're drafts. The custodian is welcome to slap draft all over it to make it very clear this is not a final record, but it is still public and it should still be disclosed. Custodians are also not required to create new records. Now, there's a big asterisk there, and we'll talk about that a little bit later on. But generally speaking, if a record doesn't exist, the Public Records Act doesn't apply to it. Custodians aren't required to create something under the Public Records Act. And so I mentioned that that it's the record that is created that's subject to disclosure, not the device. So if we take this example, a couple of Open Records counsels back, Leapope admitted that he had a bit of a thin mint problem. And so he would talk to his dealer who has worked in our office and say, John, I need to get some of them thin mints. If this email is created on his government issued, his work email address, on his work computer, sent during work hours, this is a purely personal communication. It's not created in the transaction of official government business. And so we look at the content of the record. We don't look at the device it was created on, when it was created. Looking at the content of the record, this is not related to official government business. It's not a public record. Now, in contrast, Tony and I will sometimes talk about the Desperate Housewives of Chattanooga.
The Real Housewives of Anywhere, not Desperate.
So we'll talk about that on a Sunday night.
Slow down just a little bit.
I will do my best. Sorry. So we talk about this TV show on Sunday night, and we say, oh man, did you see what that person just did? Also, what time are we leaving for that presentation tomorrow? When we're talking about the Real Housewives, that's not a public record. That's purely personal communications. But on Sunday night, on our own personal cell phones, whenever we swap to talking about when are we leaving for that presentation, what are we doing for work, those records themselves are public records. So the device itself is not a public record. The fact that Tony and I communicate about work sometimes doesn't mean that our cell phones are now subject to inspection by any citizen. It's just the records that are on those devices. So we see this a lot more in the context of law enforcement, dealing with dash cams or body cams. The camera itself, the dash cam itself, is not the record. It's only the video file that's created. The most common public records we see requested are emails and texts, but also tweets or Facebook posts or whatever else the children are doing these days. Those are all public records. Video recordings and surveillance footage are public records. It's very frequently going to be confidential, but still a public record. Also, any kind of personnel records, travel or leave information, meeting agenda and minutes, both draft and final, any kind of budget records or financial records. These are all public records. things that are not public records, records that don't exist. If a record doesn't exist, a custodian is not required to create it under the Public Records Act. That also includes records that should exist but don't. So under the Open Meetings Act, governing bodies are required to create minutes for their meeting. If a governing body just says, no, we're not going to do that, that's a violation of the Open Meetings Act. However, they're not required to go back and recreate those meetings under the Public Records Act. Public Records Act only requires 2 records that exist. And finally, information. So I'm a very funny person, if you haven't noticed. I make a lot of great jokes. Those jokes are not in the PowerPoint presentation. For the most part, unless somebody's recording these events, that's not a record that exists. And so somebody couldn't send a records request to our office and say, hey, what was that great joke you told on slide 13? It's not written down. It's not a public record. So the Public Records Act does not apply to information. And finally, the Public Records Act states the custodians are not required to sort through files to compile information into a new record or to create or recreate a record that does not exist. A custodian is not required to sort through files to compile information into a new record. However, a custodian is required to sort through in files and to find records responsive to a request. So if an individual submits a request to a law enforcement agency and says, I want to see every ticket written to a red car in this time frame, that's going to require the custodian to go through all of their files to find responsive records. That's a valid public records request. Now, in contrast, if the same person says, I want to know the date and the location where every citation against a red car was issued, that's asking the custodian to go through and compile information into a new record. And the custodian's not required to do that, with an asterisk. So custodians are not required to create new records, except sometimes they are. We call this the NES case. This is a 1998 case, the Tennessean versus the Electric Power Board of Nashville, what is now known as the NES. In 1998, I think I looked up the statistics, and roughly a third of American households owned personal computers. I know my family thought it was just a fad I'm from Mississippi. We thought it was just a fad that nobody was going to need that. And for us, at least, the internet was just like either witchcraft or a hoax. But the Supreme Court at the time, they said that the NES would be required. Sorry, more facts about the case. The NES had magnetic backup tapes. For the youth among us, that's like a giant cassette tape. The Tennessean requested information from the NES that the NES could not pull from any one source. So they couldn't go back through their tapes and say, okay, this is everything the Tennessean wants. They would have had to go back and find lots of individual data points, or they just weren't even able to go back and find it. They were stored on the tapes, but they didn't have a way to access it. The Supreme Court said that the NES would be required to offer to hire a third-party programmer to go back and review the magnetic backup tapes to pull the information the Tennessean had requested. Now, retaining a third-party programmer to go back and review records and create records that didn't exist was not creating a new record at the time. That was a cost that the NES could pass on to the Tennessean, but still something they were required to do. So the Supreme Court at that time, they were treating the magnetic backup tapes as the record. So the tapes themselves was the record. The information was on there, even if it wasn't readily accessible. The way I think we would apply that today would be anything that's found in a single database that can all be pulled from one single source should be treated as one record. The best example, and we tried to get screenshots, but we weren't able to. The best example of this, I think, is our system called Impact. Impact is a system used by county property assessors and county trustees and by our office. It has a lot of property records. It has historical assessment data, also records about property tax exemption. So an individual could request from our office the assessed value of a property in 1993, 2007, the owners at the time, the tax exempt status of the properties at the time, and the dates of all hearings for both appraisals and tax exemption. That's all information that will be found on 5 or 6 different screens. So there's no one place we could go to an Impact and say, okay, here's this information, here's the record you wanted. What our office would be required to do would be to craft a query that would pull this information from Impact. So this is not something that exists by itself in Impact, but it's something we can pull. We would be required to go through and craft that query to pull all of that information. Now, the time it takes to do that is a cost that we could pass on to the requester, but we would still be required to do it. Now, in contrast, If the requestor also wanted to know who was the governor of Tennessee at the time that each of these appraisals happened, that's information that is not found in impact. So because you're now pulling information from one database and from another source, that's where I would say the NES case cuts off. A custodian would not be required to do that. So again, this is 1998. The nature of data is fundamentally different now. It's kind of hard to make this case apply now, but it is currently the law of the land, so we do the best we can. And we'll go back to Tony for exceptions.
All right, so all public records are open to any Tennessee citizen unless they're not. And then here is the unless they're not portion of the presentation this morning. So as you can see, there are over 50 exceptions to the TPRA contained within the TPRA itself. That's Seth mentioned earlier that the heart of the TPRA is found at Tennessee Code 10-7-503. 10-7-504 is where you will find these 50 plus exceptions within the TPRA itself. Now, there's 700, well over 700 at this point, found somewhere else within Tennessee law that says these records are confidential. So state law can include anything from separate statutes to the Tennessee Constitution, common law, rules of court. You'll really understand that when we go through the Tennessee Rules of Criminal Procedure, Rule 16. We'll talk about that in depth, and that's what rules of court is referring to. Any rule of court that would otherwise make something confidential is also going to make it confidential under the TPRA. Administrative rules and then regulations. So anything that creates confidentiality within the law is also going to create confidentiality under the TPRA. So this is the OORC report on statutory TPRA exceptions is what I was talking about earlier, the public-facing exception database that you can search on our website. All right, so some of the most common exceptions to the TPRA are listed here. TBI files are generally confidential medical information. That's where a federal law is going to apply to local state records. So obviously HIPAA is a federal law. Any covered entity under HIPAA is also protected under the TPRA as far as not having to turn over those records. So it keeps a doctor or a nurse who works at a state-run hospital for some reason having to disclose medical information about a patient because they got a TPRA request, while they're also prevented from being able to do that under HIPAA. This is how that applies under the TPRA. FERPA is, student information that educational institutions have about students. That's protected under the TPRA because of FERPA. Juvenile information is one of the trickiest, most nuanced sort of arenas within the TPRA and confidentiality. I always just like to say, if you get a tricky juvenile question for confidentiality purposes, reach out to our office. Sometimes it's open, sometimes it's closed. Sometimes the same information would be available in the hands of one person, but it's confidential in the hands of a different governmental entity. So with that, it's best to just reach out to us if you have a question about juvenile information. Expunged records. So when a record becomes expunged, the records surrounding the charges that were eventually expunged should be destroyed. So they shouldn't even be available. If for some reason they are available and you receive a request for information surrounding a record or a charge that has been expunged, obviously it's confidential. And that's one of the even trickier situations where usually under the TPRA, you explain this record request is denied, it is confidential under, and you give, an exception record or an exception citation to why it's confidential. But you can't say this record is confidential because it's been expunged. That also comes up with DCS things that have been referred to DCS are confidential. Well, you can't say this is confidential, your request is denied because it's been referred to DCS. So I think maybe the best response to something where you've got an expunged record is we do not have records responsive to your request, or here are all of the records that are responsive to your request, if you have some information that you can hand over. Tax information is going to be confidential, and then all of your traditional professional and client privileges also extend under the TPRA. So an attorney-client privilege, therapist, patient privilege, all of those privileges are also going to be create confidentiality exceptions under the TPRA itself. And then criminal investigations and prosecutions, we'll talk about that in more detail here in just a bit, but that's going to be referring to Rule 16. Now, personally identifying information. This is where there is a record that is open, but is going to require some redaction. So anything that lists a person's social security number or their official driver's license number, any of these things that are included within a public record would have to be redacted. I do think one of the interesting things here is that you do not see address and you do not see date of birth. So just strictly speaking, under the TPRA, for general records that are held by a governmental entity, your address and your date of birth are not confidential. But when you move into personnel records, so this is going to be about records that are held by a governmental entity because they are the employer of a person. So if you reached out to the Comptroller's office and asked for a personnel file, all of the things on the previous slide plus all of these things would also be redacted. So you will not get my home cell phone number by requesting my personnel record from the Comptroller's office. The same goes for my personal email address. Now, my state-owned and issued email address, if I had a work phone, like cell phone, then those numbers would be open. But my personal contact information would be redacted out of those records. That is also true for residential street addresses for non-state employees. So that's more like a municipality or a county who is an employer of a person. Then they would just redact out the residential street address. Bank account information, health savings account, all of that stuff's going to be redacted out of my personnel file or any other personnel file of a state or other governmental entity employee. And that's true for my immediate family. Any of the contact information that the Comptroller's office would have for my husband as my emergency contact, that's not available to the public based on a TPRA request. And then when you talk about law enforcement personnel records, they have even more protection. So you get all of the things that were redacted for just personally identifying information. And then, of course, law enforcement officers are employees of some governmental entity. State, county, city, however that works out, they're also going to have these, so the information in the previous slide would also be coming out for them, and then this additional information comes out. I think what's most interesting is the protection for law enforcement officers' children, where those children are enrolled in school or in daycare or after school programs, things like that. That information comes out of the record, and the law enforcement officer is notified within 3 days that their personnel file was requested and that it was turned over. 3 business days. So Rule 16, we kind of touched on this a little bit, but to kind of really drill down on what it says, it's an exception that comes into play quite a bit. So any ongoing criminal investigation, any investigatory files surrounding that ongoing criminal investigation or prosecution are confidential under Rule 16. So it keeps people from being able to sort of circumvent the rules of criminal procedure in order to receive information that will eventually be open, but is not yet open. So you have to go through the discovery process, and information is turned over to the defendant at appropriate times throughout the pretrial hearings and, in preparing for the trial. But you're not going to have an attorney be able to reach out to law enforcement officers, submit a TPRA request, and then receive information that is not otherwise open yet. And then again, this is a good place, I think, to point out that what we're talking about today, and especially what we're talking about right now, is the TPRA. So a lot of the things that we will touch on may be open and available through other avenues. But what I'm talking about is just based on a request for a public record under the TPRA itself. Just because it's confidential under the TPRA does not mean that there is not some other way for certain people to receive certain records that would otherwise be confidential. Okay, so just to kind of touch a little bit more on juvenile information, it's generally open. A lot of governmental entities see juvenile information and they're like, nope, it's confidential. There are a lot of cases where it is confidential, but in just a general record that happens to have a juvenile information on it does not make that record confidential. Now, law enforcement records that are related to a juvenile court proceeding are confidential. So a lot of times those records are open to the attorney of record, things like that, but not based on a TPRA request. If something shows the juvenile victim of a crime, then that portion, at least, of the record is going to be confidential. The same goes for reports of harm that include or that are related to juveniles who have been harmed in some way. That's going to be confidential. Reports of sexual abuse, that's confidential information when it comes to juveniles. And then law enforcement body cameras of juveniles at school. So body-worn cameras, I think there are 3 big exceptions to when that footage is going to be confidential. If it shows a minor on school property or inside a school, if it shows the interior of a residential home that is not a crime scene, it's fully confidential. And if it shows, what's the one I'm forgetting? Residential. Yes, I think it's anything within a certain hospital or health facility that's licensed under certain other separate codes would be confidential. So a law enforcement record regarding an incident at a school is also confidential, not just the body camera footage, but also the reports of an incident that occurred on school property related to juveniles. And then proceedings involving DCS. So the provision under 10 code 10-7-504 related to DCS and making it confidential is incredibly broad and makes pretty much anything that's been referred to DCS confidential in its entirety. The security of governmental buildings. The legislature took that very seriously and again included in the TPRA itself information and records that are directly related to the security of any governmental building is confidential. So you're not going to get, escape routes for governmental buildings if there's a bomb threat or something like that through a TPRA request. That's confidential. You don't get to know the ins and outs of the security related to a governmental building. Also, you'll see sometimes with body camera footage where a law enforcement officer has to type in some sort of security code to enter different areas of a governmental building. Well, that portion, at least, of the footage would be redacted. You don't get to, get the access codes by just having having access to the footage from the body-worn camera. So again, contingency plans and security. When it comes to security, when it comes to keeping governmental employees safe within the buildings that they are required to work in, it's taken very seriously. Those things are going to be confidential. Some other common exceptions, expunged records we've touched on quite a bit. One thing to keep in mind with expunged records is that if you knowingly turn over information that is related to an expunged record, it's a misdemeanor itself. So you can actually be charged with a misdemeanor for allowing that information to get out into the public if you know that it's been expunged. Information that could locate a domestic violence or human trafficking shelter. Anything that would locate the address of or the location of one of these is confidential. And then records obtained from the FBI National Index or Identification Index, that's background checks. So if I had to do a background check before I started working for the Comptroller's office. A lot of state employees do. It was not my first time to go through a background check for state employment. And if you get my personnel file, that information is going to be withheld. And then, of course, riot, escape, and emergency transport plans of county jails and workhouses or prisons. That's all confidential. So, again, that goes back to the security of governmental employees or governmental buildings. They want to keep us safe. And I think, looking at the time, we'll take a break for about 15 minutes. Come back at 11:02.
All right, we're going to get started. We're going to move now to the boring part of the presentation. And that's not a joke. Don't laugh. This is the boring part. Sorry. We're going to talk about the more practical aspects to the Public Records Act. So we'll talk about public records policies, the process for receiving a request, for responding to it, some differences between inspections and requesting copies, redaction, denying requests, and the format of records. And we'll also talk about penalties, both for custodians and for requesters. We'll start off talking about public records policies. Every governmental entity in the state is required to have a public records policy. For state-level entities, it's technically going to be rules, but for most people, it's going to be a policy. There are a few minimum things that public records policy has to include. It has to include the process for making requests, the process for responding to requests, any required forms as part of making a request, a statement of fees and billing processes. And so, for example, that might be that, like our office says that our office only accepts payment in the form of checks, and checks have to go to a certain address, and we only respond to records after we've received payment. We only provide records after we've received payment. And the policy also has to include contact information for a public records request coordinator. There's a couple of ways of doing that. What I see a lot is that public records policies will say that our public records request coordinator is John Smith. And so then John Smith leaves or somebody else is appointed, and the public records policy then has to be updated. The way our office does it, we just have a public records request inbox. It's recordrequest.cot.tn.gov, and whoever our public records request coordinator is, we just give them access to that inbox. And that way we don't have to change our policy when our public records request coordinator changes. If you're aware of a governmental entity that does not have a public records policy, or one that needs an updated policy, we have a model policy posted on our website. Let's talk about verifying information. We talked about Tennessee citizenship earlier. Most frequently, when I was briefly the public records request coordinator for our office. For the most part, when I would get a request in, the first thing I would do is make sure that I verified citizenship. So if somebody didn't include a driver's license with their request, that was the first thing, right off the bat, ask for that. And that's an easy way to close out requests that aren't serious, that aren't made in good faith, or that just aren't going to take a lot of time. If someone's either an out-of-state citizen or refuses to verify citizenship, you can go and deny that request. The other big thing that has to be verified is what an individual is looking for. This comes in two different varieties. Sometimes an individual just doesn't know what they're looking for and they make a really vague request. Requests for public records must be sufficiently detailed to allow the custodian to identify what records are requested. So if somebody sends an email to our office and sends a request to our office and says, I want to see the emails. Saying I want to see the emails doesn't actually identify what they want to see. Do they want to see emails that our office has sent or received, emails that we use in evidence in our criminal cases, emails that we pass around the office because they're funny, which we don't do, anything like that. That doesn't tell us what records they're looking for. Whereas if they say, I want to see all emails that were sent from the year 2000 on, that is an absolutely colossal request, but it's sufficiently detailed. It does identify exactly what records they want to receive or they want to see. And so in that case, our public records request coordinator might reach out and verify, well, you want to see all of these emails that will require approximately 1 billion hours of labor. Maybe we can narrow down what you're actually looking for. And they might say, we're actually looking for records related to this. And our public records request coordinator could say, okay, well, why don't we change your request to say all emails sent by these persons during this time period with these keywords. So it's all kind of verifying information that you might do. Some of it's necessary to fill the request, and some of it's more a matter of public service, trying to identify like what record someone is looking for, and just to make the records a little bit more accessible to them. We go back to our basics of the Public Records Act. All public records are open for inspection. There are two types of inspection under the Public Records Act. There is an in-person or an IRL inspection of records, and that's an inspection in the custodian's office or on the custodian's premises. And then there's a request for copies. Most frequently, we see a request for copies. That's a request for an individual to actually have copies, either hard copies or electronic copies of a record. And these two types of inspection are treated a little bit differently. The big thing is a request for an in-person inspection of records. A custodian is not allowed to charge for that request, or charge to fill that request. So a custodian might take several hours of work to produce the records, and then they might have to have somebody sit with the requestor while they're reviewing them, but they're not allowed to pass those costs on to the requester. In contrast, a request for copies of records, the custodian is allowed to charge. Another big difference is that a request for an in-person inspection of records, the custodian has to accept that no matter how it comes in. So if an individual walks into the office and says, I want to inspect these records, the custodian doesn't have to comply immediately, but they do have to accept that purely verbal in-person request for an inspection. If it's a request for copies, the custodian can require that come in on a certain form, or at least that it come in writing. And to clarify, for a request for an in-person inspection, a custodian can still request that it be put into writing, just as a matter of logistics. It's easier to pass a piece of writing on than it is, to play telephone with a message, but they can't require that it be in writing. So talking about the time frame to respond to requests. Under the Public Records Act, a custodian has to promptly make records available, or if it's not practicable to make records promptly available, they have to issue a response within 7 business days. So records must be provided promptly. That doesn't mean the custodian is required to drop what they're doing, immediately shut the office down, and go comply with the record request. That would not be reasonable. That would not be good public service. A custodian has to make records available reasonably promptly. If it's easy to provide a record, if it's a single page, if it's right on your desk, if you know exactly where it is and can pull it quickly, then it should be provided promptly. If it's a request that will take several hours to fill, if it'll have to go through a couple of processes of review, if you're not sure whether information is public or is redacted, if you have to reach out to our office, these are all reasons why you couldn't make records promptly available. And so in that case, a custodian is still required to issue an answer within 7 days, a response within 7 days. That response can be to provide the records, to deny the request. If it's a bigger request, they can provide some records and deny other records, or to furnish in writing the time reasonably necessary to produce the records. So if this is a request that might take 10 hours to produce, the custodian can say, this will take 10 hours of labor, the cost will be this amount, and we can produce these records within 5 business days after receiving payment. That is a perfectly valid response, even though the records probably won't be provided within 7 business days. The custodian's response has to include the time frame to produce the records and has to be issued within 7 business days. Now, there are some really massive requests, and so that might be the request to receive, to review all emails sent within a couple of year period. If that's the case, the custodian might give a rolling production. So we can provide, this will require 200 hours total labor. We can perform 10 hours of labor per week to review these records. You can pay in advance, and every Friday you can pick up the records that we've identified responsive to your request. We anticipate we can finish this request within 6 months. That's also an acceptable response. That's giving the date by which the request can be completed, and it's laying out a procedure by which to produce the records. If a custodian fails to respond to a request within 7 business days, that's considered a denial of their records request, and that creates appeal rights that we'll talk about in a couple of slides. We talk about the format of records. A custodian is not required to convert electronic records to paper, and they're not required to convert paper records to electronic records. Converting paper records to electronic records is almost always the easier option, but custodians are not required to do that. Records are also not required a custodian is not required to produce records in the original file format in which they're held. So for instance, property tax records. Property tax records are typically held in a database. They might be exported to Excel fairly easily, but a custodian is not required to produce them either in the database or in an Excel format. As long as the records can be read in the format that they're produced, they can be provided in any other format. So for instance, if we provide records in Excel, we will look at our records, we will make sure that they're formatted in a way that all of the information is still organized properly. So if it's property tax records, we'll make sure that everything is still on the same row that it should be to correspond to the parcel that's the subject of the request, but we would then provide those records in PDF. So as long as the records can be faithfully transmitted in another format, that's acceptable. Now, if it would jumble the records such that they really couldn't reasonably be read, that's not acceptable. Then another alternative would have to be identified. We'll talk about charges here shortly, but if the record is being produced electronically, the custodian is not allowed to charge the cost to print the records. Charges for record request are generally going to be compensatory, and so you can't charge 15 cents per page for a record that you're not actually printing. In that case, the 15 cents per page would be compensatory for printing the record. And this comes from our schedule of reasonable charges. This is one of the documents that's found on our website, and it gives an outline of how to charge for a record request. So we'll talk about, if you talked to us before, you know that there's a 1 hour labor threshold. For the most part, the first hour of labor to fulfill a records request is going to be free. That comes from the schedule of reasonable charges. Same thing with the 15 cents per page for printed copies or 50 cents per color copy. There's also a requirement that the custodian use the lowest possible labor threshold. So for example, we can't have our general counsel go through and format records from Excel to PDF. That would be, there are lower possible sources of labor, like me, that can do that. But not every person can do every job. So if we're going through and reviewing emails for redaction, if they're my emails, only I can review those for attorney-client privilege. So while there may be other sources of labor that could review for social security numbers or other personal information, it still has to be one of our attorneys that reviews for attorney-client privilege, because not every person in our office is qualified to do that review. So a custodian is required to use the lowest cost labor possible, but it's the lowest cost possible that can do the job at hand. If there will be a charge for records, the estimate of those costs has to be provided beforehand or before holding the requester accountable for them. And again, custodian cannot charge if it's a request for an in-person inspection of records. At a certain point, custodians can charge for requests from the same individual. If it is an individual or a group of individuals working in concert that make 4 or more record requests within a calendar month, the custodian is no longer required to waive the first hour of labor for those charges. Essentially what happens is you aggregate those charges together, you add them together. So if one individual submits 5 requests that each take 15 minutes to fulfill, that's now 75 minutes of labor total. The first 60 minutes of labor are no charge, but the next 15 minutes would be charged just like normal, even though every one of those requests individually was less than an hour. And so this can be applied when it's one individual or when it's a group of individuals acting in concert. I had a reporter one time who got to the 1 hour labor threshold, and he was then very clever and emailed me and copied his comrade. And they both had the same email domain showing they worked for a newspaper. And he said, "I'm not making this request, but my friend who works with me is." Sorry, my friend, y'all are now acting in concert, very obviously. If it's a situation like that, you can still aggregate your requests. When charging for a record request, the charges are compensatory. So any other costs that are accrued in the course of fulfilling that request can be turned over, can be passed on to the requester. So we talked about the NES case. If the custodian is required to retain a third-party programmer, as long as it's a request for copies of records, that's a cost that can be passed on to the requestor. Same thing if it's something like an access fee for records that are older, or if it's just a record that has to be burned to a flash drive or burned to a DVD or put on a flash drive. The cost for the flash drive or for the DVD can be passed on to the requester. And then same thing if records are going to be mailed. Now briefly, the grounds for denying a request. If a custodian is not actually the custodian of a record, if this is a record found in the custodian's office that was not created in the course of official government business, that they don't have for any sort of work-related reason, they're not the custodian of that record. As a practical matter, this is very rarely going to come up. For the most part, if a governmental entity has a record, they have it in the course of doing their official business. So that's not one that will come up often. If a request is insufficiently detailed, such that the custodian cannot determine what records the requestor is looking for, that's a valid reason to deny the request. If a requestor is requesting records that do not exist, that's a valid reason for denial. or if a requestor is not a Tennessee citizen or refuses to verify Tennessee citizenship, if an individual refuses to pay the cost to produce records, the request can be denied, or if a request makes the entire record confidential. For the most part, records should be redacted rather than being held as confidential. So if you have information on me that has my personal address on it, generally my employer would redact my address out of that information rather than saying the entire thing is confidential. In cases like DCS or juvenile court records, in that case, generally the entire record would be confidential, and so that would be a reason to deny the request. So generally speaking, two types of penalties. There are penalties for requestors and penalties for custodians under the TPRA. If an individual makes a request an in-person inspection of records twice within a 6-month period, and then fails to view those records within 15 days of being notified that they're available, unless they have a good cause to miss that inspection, the custodian is not required to comply with any further requests from that individual for a period of 6 months. So 2 times within a 6-month period, somebody says, hey, I want to come look at these records, let's come do it tomorrow, and then they don't show up, and it's because they're hungover. That's probably not good cause. You're not required to comply with further requests from them for 6 months. If there is good cause, if there's a death in the family, that likely is good cause, and that penalty would not apply. If it's a request for copies, if the individual agrees to pay the cost and then does not. So there's going to be a $30 cost. The person says, yes, I will pay that $30. The custodian then incurs $30 in costs, but the requestor refuses to pay for it. At that point, the custodian is not required to comply with any further request from that person there is no time frame on that until they pay for the records that they agreed to pay for. Now, for custodians, if a request is denied, that gives an individual the cause of action to bring a suit under the TPRA in either the Chancery or the Circuit Court where the records are located. Now, it's our opinion that applies to both an actual denial or an effective denial. So if a custodian denies a record request, if they fail to respond to a record request, that's deemed a denial. Or if the custodian gives an unreasonable amount of time to produce the records or an unreasonable cost to produce the records. Those are both an effective denial of the record request. So it'll take 2 years to produce these records. That's effectively denying access to them. Or it will cost $5,000 to produce a fairly simple record. That's effectively denying access to it. And it's our opinion those would all create appeal rights. At the point that a suit is filed, the burden is on the governmental entity to show that a denial is justified. So if it's the case of an actual denial, the governmental entity has to show they requested these records are confidential under this statute. If it's an effective denial, the burden would be on the custodian to say, yes, we quoted $5,000 to produce these records because it would take this amount of manpower. And the burden would be on the custodian to show that amount of manpower is reasonable. So a lot of times people will contact our office and they'll say, is it reasonable for us to take 6 months to produce these records? We can't tell you. We don't know what custodians' file systems are like or what their manpower availability is like. The best we can say is that if a custodian would feel comfortable testifying under oath, this is the amount of time, this is the cost, this is the manpower we had available, that's the standard to use to determine if it's reasonable. And Tony mentioned earlier, if a denial of records is found to be willful, the court can order the custodian to pay the reasonable attorney's fees and cost of collection to the requestor to find those records. That's only in the case of a willful denial or a bad faith denial. So if the governmental entity knew that a record was public and willfully refused to disclose it. And so again, contacting our office. If you can show that you contacted our office and then followed our advice, that's going to weigh in favor of that a custodian was not acting willfully, that a custodian was acting in good faith when denying a request. So that finishes the TPRA portion. We have 2 more things to touch on. The first is the Safe at Home program. We have some brochures about this program. This is a program that came about in 2019, and it's run by the Secretary of State's office. However, it touches on the confidentiality of individuals' addresses. So it's codified at Tennessee Code 4038-601. And what this says is that victims of domestic violence and other crimes certain other specified crimes, and their children can have some sort of some sort of confidentiality for their address. An individual applying to be in the program has to show that they meet the requirements for it. And so that would be that they're the victim of domestic abuse, stalking, human trafficking, or other specified offenses. They show they qualify for it, and if they're approved, they essentially get a substitute address or a dummy address. They get an address that they can give in place of their own address for voter identification or driver's license, and their mail will be forwarded to the Secretary of State's office. The Secretary of State will then forward it to their actual home address, and in the hands of the Secretary of State's office, their address is confidential. So this is not a program that our office administers or touches. However, we felt it important to mention. And if you're interested, we do have more flyers available up here. And last thing, records retention. I love talking about records retention because it's something that we don't really do. For the most part, records retention, or an RDA, a record disposition authorization, most governmental entities will go to either MTAS, the Municipal Technical Advisory Service, or CTAS, the County Technical Advisory Service. Would mostly go to those two. A custodian would mostly go to one of those for help with their RDAs. The only RDA that we really can touch on, the Public Records Act 107503, states that all requests for public records must be retained for 12 months. So that's the request itself, and then any verification. So the email where one verified the citizenship or verified what the individual is looking for, and then the email is talking about the cost to produce records. Those all have to be retained for a period of 12 months. And that only applies to the request and the verifications. It does not apply to the actual records subject to the request. Those are subject to their normal RDAs after the request is satisfied, with the only exception being that a custodian cannot destroy records that are subject to an open records request. And now we'll move to Toma, and I'll turn you back over to Tony.
All right, so we've talked a whole lot about the TPRA, and now it's time to give Toma a little bit of attention. I want to make sure that we leave plenty of time for questions at the end, but I think we have plenty of time to get through Toma, have questions at the end without having to rush through. So the foundation of Toma is sort of the idea that the formation of public policy is public business and should not be conducted in secret. So just like the TPRA, it is to be construed broadly in favor of the public and in favor of openness. It provides citizens the right to attend and the right to participate in open public meetings. And it applies to all meetings of any governing body. So what is a governing body? Well, it's very boring, but members of a public body of 2 or more members with authority to make decisions for a recommendation to a public body on policy or administration. That's a governing body. If a entity meets that definition and they're having a meeting that has anything to do with public business, then that meeting then has to be open. And it includes some nonprofits, but usually it's going to be governmental entities who are having meetings. It does not include advisory committees created by a single official. But we know now that governing bodies or that any meeting of a governing body has to be open to the public. Well, what is a meeting? It's the convening of a governing body, of a public body, in order to make a decision or to deliberate towards a decision. You see that I've crossed out for which a quorum is required. That's because in the most recent legislative session, they got rid of that portion of the definition of meeting. So this feels like a really important or a really good point to kind of mention a very important point, being that what we're talking about today, everything in this slideshow, everything that Seth and I say is sort of the TPRA and Toma currently. It's not, we never know what's going to change in the next legislative session. We never know when these things are going to be. There could be big changes or small changes. What we're talking about today is currently how Toma and the TPRA have been constructed and how we've been directed to construe those by the courts. But the really important thing about meeting here is that anytime you have a meeting, you want to make sure that it, not only is it open, but that any deliberation happens in that public open meeting. So you can't have deliberation behind closed doors and then have an open public meeting for appearances only, now that everybody's already talked about everything and they know how they're going to vote. So now we can go out, face the public, and do what we've decided to do. So deliberation has to occur in that meeting. You can't have, emails back and forth about how you want to vote on something and ask a fellow board member how they want to vote on something and get your mind made up. That all has to happen in a public meeting. We've even had some allegations against some boards. It's been forever now, but I went to a public meeting and I saw one council member texting a different council member, and I know that what they were texting about during this meeting was how they were going to vote. I don't know if that was the case, but if that was the case, not only have they violated TOMA, but they've also created a record in those text messages that would be open to the public based on a TPRA request. So you want to make sure that anytime you are, having a meeting, that all of the discussion, all of the deliberation about anything that is going to be voted on or, a matter of public business is discussed in open in that meeting. Now, this does not include some things that we'll go over in just a little bit: executive sessions, informational workshops. It's not that they are an exception to open meetings. Usually what we see is that they're not really considered meetings themselves. There are a few where they would be considered an exception to an open meeting, but generally what you'll see with the exceptions to the meeting is that they're really not meetings. All right, so what does TOMA require? It requires that any meeting must be open to the public. After adequate public notice has been provided, there has to be an agenda within 48 hours, or an agenda 48 hours in advance of the meeting that's available to the public in an accessible place and that's free. You have to keep meeting minutes. That's going to include the people who are present at the meeting, motions, proposals, and resolutions that are offered during that meeting, and then the results of all votes. And all of the votes have to be public. So you can't have secret votes during these open meetings. It has to be a public vote. And now we have the opportunity for public comment. So that's the ability for the public to participate in the meetings in addition to attending them. So adequate public notice is required under TOMA, but not defined under TOMA. So TOMA says you've got to do this thing, but we're not going to tell you what that looks like exactly. What we do know is that 48 hours of notice is insufficient. The courts have told us that. Otherwise, the rule of thumb that I think is best to think about is, am I giving the public enough notice that anyone who is interested in exercising their right to attend the meeting has the ability to do that? So do they have enough time to make arrangements with work or make arrangements with childcare that may need to be made so that they can attend this 6 p.m. meeting? You have to give them enough notice to be able to do that, so that they really do have the right to exercise, or really do have the ability to exercise their right to be engaged citizens and appear at the meetings that they're interested in appearing at. For a regular meeting, notice only has to include the time and the place of the meeting. For a specially called meeting, you have to include the time and the place, and then reasonably describe the proposed actions to be taken or decisions to be made. So if you're calling a special meeting, you have to say it's going to be, at this time, at this place, and here is why we're calling the special meeting. We have to discuss and figure out this thing. And then you cannot go outside of those parameters. For a special meeting, you can't talk about, deliberate on, vote on anything that's not already included in that notice to the public that you will be talking about. Now, the public comment period in terms of law is still considered relatively new. It went into effect July 1st of 2023, but the reason it's still considered new a year and a half later is because the courts have not had a chance to address this. There has been no suit where the courts have said, this is how we interpret these requirements. So all we have at this point is the text of the statute itself, which says that you have to reserve a time period in any public meeting to allow the public to offer comments. We know that there can be reasonable restrictions placed on that, and we know that these restrictions are considered reasonable because they're listed out in the law itself. So you can limit the length of total time for public comments. You can say, we're going to have public comment period for 30 minutes at this point in the meeting. You can limit the amount of time that each speaker has. So you can say, we're going to have 10 people who have 3 minutes to speak each for a total of 30 minutes for our public comment period. You can require advance notice. If you require advance notice, you can't hide the ball and say, let us know, but we're not going to tell you how to let us know. Let us know that you are interested in speaking, and you can let us know that you're interested in speaking by emailing this email address 48 hours in advance, or however you want to make that requirement. You can also limit the number of speakers. I think I've already kind of touched on that. The other thing is that you have to the best of the governmental entity's ability, allow both viewpoints to be represented fairly. So if there's something that you're hoping to pass during this meeting, you can't say we're going to have 10 people speak and we're going to make sure that they all speak in support of the thing that we want to vote on. To the extent possible, you have to have, the both viewpoints represented fairly. Oh, and any public comments that are offered in a public meeting have to be, or can be required to be, germane to the items on the agenda. So a governmental entity is not going to be required to hold space for someone to come in and talk about the weather for 3 minutes if they're not talking about the weather. They can even require citizens to say, this is the item that I want to speak on, agenda item number 3. So, agendas. Before this most recent legislative session, only local governmental legislative bodies had to have an agenda available. That has now been extended to state governing bodies. So now state or local governmental legislative bodies have to have an agenda available to the public at no charge, 48 hours in advance of the meeting. And the agenda has to reasonably describe what you're going to be addressing during your public meeting. But you can, if something comes up, say you have this agenda set a week and a half before the meeting, you make it available 3 or 4 days before the meeting, and then all of a sudden you have a thing that comes up that you need to address at this meeting. You can add items to the agenda during the meeting, so long as you're not doing that and leaving them off of the agenda to violate the spirit of TOMA. It truly needs to be something that came up after the agenda was created, and it needs to be addressed, and you're having to add this item, but you didn't leave it off the agenda intentionally. Okay, so executive sessions. These are the situations where some are considered not really meetings, and some are true exceptions to TOMA. So if a board is having a meeting with their attorney to address some sort of litigation that is before them, maybe they're trying to figure out whether they should accept a settlement offer or something like that, as long as the meeting is truly the attorney kind of providing the information to the board, not the board discussing and deliberating in private, but usually we think of it as information flowing in one direction. The attorney to the board, here's the legal situation. They can answer questions that come from the board about that legal situation, but they can't have, you're not going to allow the board to have deliberation during this closed meeting. But that's to protect attorney-client privilege. To have these meetings closed. You don't need to provide notice to the public, hey, we're going to talk to our attorney about this issue. And usually it can be done before or after a meeting so that the public's aware. It's not something that you're hiding the ball on, but you don't have to allow public comments periods and things like that. Informational sessions, that would be a situation where perhaps all of the members of a single board attend one of these presentations. Again, they don't have to provide notice, hey, we're all going to this presentation and we'll hold a time period for public comments halfway through when they take a break. That makes no sense. As long as information is flowing one direction and they're not deliberating about any public business, then they can attend a workshop like this. They can attend an educational session to learn more about how to follow the requirements of TOMA without it being a violation of TOMA itself. School safety planning meetings are meetings that are an exception to TOMA. So school boards can have closed private meetings where they're discussing school safety and how to keep our children safe in schools. And those do not have to be open to the public for obvious reasons. So what happens if you violate TOMA? Well, you should not violate TOMA because you should have attended one of our workshops, one of our presentations, and you should be following everything we told you to follow. But if for some reason you violate TOMA and you end up in court, any action that was taken in violation of TOMA can be considered null and void. Now, you can go back and sort of ratify those decisions by essentially redoing it. Court says you violated TOMA in this meeting, and so all of these decisions that you made in this meeting are now null and void. It's as if they never happened. Then you can come back and say, all right, well, we're going to do it right this time, and you follow all the requirements of TOMA, deliberate in public, provide adequate public notice, and then you can sort of vote on those issues and enact whatever it is that's been nullified. The court would then also have broad jurisdiction to issue injunctions, impose penalties, and otherwise require or enforce the purposes of TOMA. And they can retain jurisdiction over that governing body for a year, requiring semi-annual reporting of the board to the court to ensure ongoing TOMA compliance. Well, now, effective May 28, 2024, just like with the TPRA, if you violate TOMA and it was a willful refusal to comply with the requirements of TOMA despite knowing the requirements, then the court can also require that the governing body pay attorney's fees to the violation or to the violating board, to the citizen who has brought the violating board to court. So any reasonable court costs or attorney's fees can be charged against the governmental entity if they willfully violated TOMA. Now, any questions?
Under Title 49 school board, we have an executive committee and have certain parameters. Well, the current new school board has decided that they want these sessions filmed. Therefore, creating a public record, but they're saying they're not accessible to the public. And what I brought up is saying if you're making that record, then it becomes, because it's only be privileged to the board.
For school safety meetings?
Executive committee,
okay.
Which is the superintendent and the chair.
Okay.
And so the board, they voted them in and then they say, but we don't trust you, so we want to film you. And in our policy 1201, they report under section 7 back to the board what they do during the executive committees. And this is going from disciplinary issues, student issues, FERPA, HIPAA, could be contracts, lawsuits, and all that. They kind of do the preliminary under whatever title they have. They do these responsibilities in Title 49. And it's never been on film. Now they're filming it. They're creating that public record.
So they are creating a record.
On purpose, yeah.
And then if they get the request for the record, I think the question would become, are portions of or the entirety of this record confidential? So maybe it's redacting the parts where they're talking about FERPA things. And
well, the question I asked, never got a response from our lawyer, was, is this subject in any way, because the way I read law is it's going to be subject to the Open Records Act, because in the past it's been excluded because it's not a public session. But if the board is creating it and it's an approved board and committee, we're now putting it into the public arena and you're creating a public record.
Right, so any record that's created by a governing body would be a public record. But then the next question is it confidential for some reason? So all public records are open to any Tennessee citizens unless they're not. So it could be that now that they're creating that record, the entirety of it is open, or it could be that certain portions need to be redacted because they're confidential for some reason.
And that was my concern, because they're saying, well, no, none of it's going to be. I said, no, that's not right. Because if you're talking about contracts, that now is in the public arena. If you're talking about a lawsuit, no, that is not. If you're talking about a disciplinary issue, not really, unless you redact certain portions. If you're talking about gang activity, that's out because that falls under your school security systems. And so that goes to executive session, that's outside the scope. What my saying is you should do this film, you're creating a record, and because you don't trust the chairman, I don't care, then remove the chairman. But if you're creating a public record, now you're creating an issue because you have to reject a lot of stuff. Like if we want it on our films, a parent can't come in and say, I want to see what happened on this bus because this fight occurred. I can't because FERPA does not allow me unless I get the software to black out all the other shootings.
Right. Yeah, it sounds like you're correct. Like I'm not going to say don't create a record or something like that, but no, it sounds like you're right. Like you're creating a record, you're creating information that you're putting information in the record.
Our lawyers, I know, is under I said I can't find that exclusion because there are exclusions, but there are some that you're excluding me to the public.
Right.
Thank you.
Oh wait, we've got somebody in the front, and then I've got you in the back.
Okay.
No, go ahead.
We had asked a question during the break, but can you elaborate a little bit more on the juvenile petitions?
So petitions for juvenile court proceedings being public to or open to the parents of the juvenile.
That's hard.
Yeah.
I'm not aware of any provisions in law that allow like a parent to receive anything from a juvenile court. At the same time, a parent has to know when to get their kid to juvenile court. So I think that's more going to be a matter of due process. As a matter of due process,
Not the TPRA.
not the TPRA, right? A student will be allowed to know when they're supposed to be in court. So they would be entitled to receive the summons or the court dates, whatever else. Under the TPRA, though, I don't know of any reason they would be public.
Okay, it's a little confusing because the juvenile obviously has to be in court with a parent.
Right.
So at the same time, the parent needs to know actually what
Right.
charges
But
the child has.
I think that's separate from the TPRA.
Okay.
So that's, the TPRA is a situation where a governmental entity has a form that any citizen can fill out and provide their photo identification and submit it to a governmental entity and receive a public record.
Okay.
That's what the TPRA is about.
Okay.
Not about how, what this parent is allowed to receive about their student or about their child and how we're going to make sure they get to court. I think really that's outside of the TPRA.
Okay. I understand.
I wish we could be more help on that, but I just think it's...
That's okay.
We had a question there.
They recently changed the notification for public hearings for zoning-related issues to 21 days, right? That started July 1st, is that correct?
That's more detailed than I have off the top of my head. I'm not entirely sure.
They did, I will say,
There's only so much room in here.
So the problem with it is that a lot of small communities like ours have a weekly paper, not a daily paper. So I cannot do a zoning ordinance change or a zone change within 2 months. I have to do it or I have to call a special board meeting prior to it so I can get my 21 days in the paper before the public hearing for the zoning change. So I want to know who's responsible for that. No, I'm only kidding. I'm just saying they probably need to take a look at that. So I can change municipal code in Fort Town with 15 days notice, but so for zoning, it's 21 days and it makes it difficult.
Sure, I understand. So for zoning, is there a requirement that it be published in a paper?
Yes.
Okay.
Local papers.
Right. So under the Public Records Act, we could say there are other ways you could provide notice, maybe like a county website or a city website. But if there's a specific requirement for that, that one type of notice, we can't offer any help there.
Yeah. It makes it really difficult.
Sure, I understand.
Whoever decided to do that doesn't have a weekly paper in their county.
Could be. Any other questions?
Okay. For the open meetings, can you, piggyback, say if you have a hearing for a grant plus your public input meeting, do you have to have them separate or can you combine them?
I don't know that TOMA specifies.
I think that's one that's just more detailed that we would have to look at individually.
Okay.
There's,
Yeah.
I mean, there are some things where TOMA, these are the requirements of TOMA, and then we can answer those questions pretty easily. Sometimes we need to go back and do a little bit of research and see if that's something that we can really offer advice on. And that just seems to be a little bit too much specificity for this setting.
Yeah, my question was kind of around security cameras, like we're a municipal utility, so kind of the different pieces is obviously like a security camera in a board meeting, kind of similar to his, but there's no audio, is that subject even without the audio? Then you also get in like law enforcement requests, we have anything that's facing that maybe an accident happened nearby, those sorts of pieces. So.
Yeah.
So security footage is generally going to be confidential as exposing a security vulnerability. And so depending on the footage itself, if it's like if it was footage of just this meeting, that may not actually present a security vulnerability for the building. And so the building may say, no, that wouldn't be confidential. As far as whether security footage that is confidential, that would reveal a security vulnerability, as far as whether it's available to law enforcement, that's another example of something that's just done outside the TPRA. So if law enforcement needs to review a record to determine if a criminal act occurred, you'd probably, you would have to ask your attorney. You'd probably go ahead and give it to law enforcement, though, with a not say this is confidential under the TPRA. And likewise, if a criminal case resulted, then anybody as part of the case would be able to subpoena that information. And so that's also outside the TPRA.
I'm a clerk and master, and the statute says that we can charge 50 cents for a copy for black and white. That the schedule of reasonable charges and our records policy says 15 cents for black and white, 50 cents for color. So do we need to update our records policy to say 15 cents for black and white copies, but for the courts, 50 cents? Is that anybody ever ran into that?
We've addressed that before, and I forget the exact answer. I want to say that's like one of the weird specific exceptions where the clerk and master's office is allowed to charge more. I would have to look at that for sure, though.
But that sounds familiar to me as well.
Right.
So let us look at it and maybe submit an inquiry so we can get you an actual answer. But I think that's correct.
Yeah.
Sounds familiar to both of us, but
Again, it's only so much room.
yeah.
Anyone else?
Regarding the Open Meetings Act, you talked about that we're to publish an agenda to that meeting. As a county commissioner, is that only for the commission meetings? We have many committee meetings. So do the committee meetings also need to publish the agendas?
At the local level, it's only, what is the wording?
Local
government.
local legislative governmental bodies.
Yeah, so we interpret that as being only the top level body. So for a county, it would only be the county commission, and then like the different subcommissions or the different commissions under that are not subject to it. Just the top level body.
On the open records aspect, the record custodian, who is that? Is there a specific elected official that automatically falls to, or who is that?
I think it's usually more of just a job position. So within our office, it was Seth for a very short period of time. Now our public records it's a different employee, but our public records policy always just says records custodian, gives the general email address for that person so that as the job title changes or as the employee changes, they don't have to update the policy. But it's just whomever the governmental body has said is the records custodian.
And that's the public records request coordinator. As far as who's the custodian of a record.
Oh, yeah, sorry.
That gets really hard. So like some counties will say that the county itself is the custodian for all records in the county, whereas other counties public records policy will state that this applies to all county bodies except. And it'll say the county assessor can have their own policy, the county trustee, sometimes the county sheriff's office. So that really varies by county.
Is the custodian as a person themselves is what I was asking. What
Okay.
That person that's going to be in charge of that, be responsible for that, be,
Yeah, that should be set out in the policy, like who the public records request coordinator is.
but it could be, it's not a specific official, it can be anybody.
Right.
All right, we had Savannah, and then you're next.
Regarding the agendas, is there anybody specific that is like required to create the agendas? And then the second part is, can they pass that agenda around as far as like we want to kind of talk about, actually kind of we want this and this and this, and then they may end up kind of conversating over the agenda? Is there any rules regarding the agenda as far as that goes?
That it has to be available 48 hours in advance, free to the public, and you cannot create a deliberative opportunity in creating the agenda.
So that's a really fine line to walk between setting your agenda, like what needs to be on it, and deliberating it. So generally there'll be like one coordinating official within the county who's not on the board, and they'll be the ones who kind of set the agenda.
So it has to be not on the board?
It doesn't have to be. It's just easier that way, because that way, like you can have, I don't know, secretaries and then go to the board members and say, we're going to talk about this thing. And you can't use that person as like a way to play telephone and say, well,
Right.
you know, this person said this. But that way, you know, that's one person that can go to each board member and say, this is what we're talking about. So there can be some level of preparation.
So there's not a requirement of who actually makes it?
Right. Not in state law.
Back to the public records custodian question. It's always been my understanding, even though I was volunteered for this, it's not by choice, but the public records custodian is only the facilitator of the flow of information. We're not required to go out and gather this and then distribute it. I mean, I send a request. Well, I get a request, I determine which department might have responsive records. I send it to them, say, here's what I need, and they send it back to me. Now, they either send the records back to me, or they say, these records don't exist, or for the sheriff's department, this is still under investigation. Then I communicate that via response form to the requester.
Right.
That's all I've got to do, right? Pretty much.
It's going to change by entity. And generally speaking, that's how we do it too. So our public records request coordinator gets the request. He says, well, property assessment and state assessed properties probably have these records. And he essentially, like you said, just handles coordinating, getting the records, and then communicating that back to the requester. It could be, like, we could do it otherwise, though. We could say that he's responsible for actually going and pulling those records. And he would hate that, but if that's how we said to do it, that would be the rules.
Okay, but I'm not going to go down to the building department and pull building permits.
Most likely that's not your responsibility, but I guess it could be.
Okay, thank you.
I got a question. I just want to clarify. We work in general sessions with warrants and all that, and we always have calls of where people are wanting to get information in regards to a criminal arrest or something like that. How do we determine what's public, what information we can share, and what we cannot? I think that
It's not really an easy answer there. It's going to be case by case. If it's something that's currently ongoing, probably most information you could share for an ongoing investigation or ongoing prosecution is probably going to be confidential. And that's under the Rule 16 of the Rules of Criminal Procedure. So for something that's ongoing, probably not a lot you can share. For cases that are closed for cases that are either finished where the prosecution is completed, the appeal periods have run, and it's just fully done, at that point it would be any other rules of confidentiality that might apply, but not Rule 16.
So basically, if it's an open case, don't share, pretty much.
Pretty much.
Okay.
It may be that there's information you could share, but that would, you would be the one looking at the case file. You'd be in the best place to know.
Thank you.
Yes, sir.
And on that same topic, Tony clarified it earlier, and I just want to be sure, that ongoing investigation exemption is only for criminal cases, correct?
Correct.
So all these attorneys that are using us, or me, to do their discovery work, we still have to do.
Yep. For civil cases, yep.
And piggybacking off of that, if someone should call into the office and ask, and we have no idea who this person is on the other end, but they're just wanting information on that case, such as court date or are court dates allowable?
The dates that you're holding court, probably. So like the juvenile court is in session at this time period, but like the court dates for a specific person is probably confidential.
But that's a request for information.
Right.
So they're not asking for a record. You're not required to provide the answer to that question. They're saying, when is court? They're not asking you for a record. If they said, can I have a copy of the docket or a copy of the, whatever it is that reduces that information to a record form, then then the question becomes, do I have to, redact any of this information? Is this open? Is this not open? But and that's something that governmental entities would save themselves so much grief. And it can be very gray, but a request for information is not required to be provided. Like, the answer to a question is not required under the TPRA.
Okay.
Good.
So we get records requests like by fax, like some come from TPI, some come from the nursing board, or like DCS. When they're asking for specifics, full names, date of birth, social, and all this stuff, or do you have any records for a certain date, are you allowed to give that information?
Information that's redacted, no. That one specifically, that information should not be turned over. It sounds like you're mostly asking about different government agencies, though. So under the TPRA, that information might be confidential. But if it's government to government, that's generally not going to be under the TPRA.
Okay, but the nursing board, can you give it to them?
I would think so. That's probably a board under the Department of Commerce and Insurance, so it's an entity within the state.
Okay.
So there may be some instances where information is just flat out confidential, and that would be something like an expunged record. Like, that information just shouldn't be turned over to anyone. But generally speaking, if it's for like a law enforcement purpose or even like a regulatory purpose, like a nursing board, that information can probably be turned over even if you wouldn't turn it over to the general public.
Yeah,
Hold on, we had somebody over here.
But in general, the governmental request doesn't go through the same process. You can send that without them submitting a public records request and proof of ID and all that, kind of like a professional courtesy thing.
Right.
Yeah.
The TPRA allows for public records to be available to any citizen of the state unless they're not. So it's about citizens having access to public records, not governmental entities sharing with other governmental entities. That's just different from the TPRA itself.
So any other governmental entity, county, state, if they request information, most times it comes through my desk and I'll contact, the court or the sheriff's office, and I just say, send it to them direct.
Or you could ask your county attorney if there's anything that you're a little bit unsure of, and they should be able to provide some information about, their opinion on whether it should be shared or not.
Yeah, so it's generally true. There may be like specific exceptions, like with the expunged records, but for the most part.
Right, yeah.
Who's the next question?
This lady's been waiting.
Me?
Yes.
Okay. If we would like to update our public records policy, who initiates that?
You were with a county, correct? You were with one of our counties, right?
Wayne County.
Yeah, so it would be the county commission.
County Commission.
And then we had, there's another question.
I was gonna say, also in our office, when the attorneys request information in regards to the case that they're representing, we ask them to send us something in writing.
Mm-hmm.
Is that proper or not?
It makes sense to me. If they're acting on behalf of their client, they need to be able to show that they're acting on behalf of their client.
Right.
But also they can request the information in their own name. It's like if I was representing Tony, I could say, I'm representing Tony and I'm requesting this information. Here's Tony's verification. Here's our engagement letter or whatever. But I could also just request the information myself. So it kind of depends on how they're acting, like who they're acting as.
It's kind of back to the topic of the personal phone versus a company phone. I know that gets to be a little sticky. Practically, as an organization, if you suspect someone has, how do you go about that whole, what's the practicality of that piece?
Yeah, if you do the best you can.
Yeah. But also, it's not really that tricky because it has nothing to do with, you're talking about public records, nothing to do with the device. It can be your personal phone, your mom's phone, or your governmental issued phone. It's the information that was created using the device. So if it's a text message that's talking to your wife about weekend plans, that's not a public record, no matter what device it's from. But if it's a text message that's talking about some, governmental responsibility, job requirement, it doesn't matter what phone it came from. It's a it's a public record.
As far as how do you know the records exist and how do you get them turned over though?
Yes,
Jordan, our public records request
Yes.
coordinator, he has no idea what the three of us are texting about. You trust your employees. If you find out that they're lying to you, you make it sure that they know. If you don't turn these records over, we're the ones who are going to have to pay for it. And you have to do the best you can with it.
And so like if that record request, you have to notify employees, if you have text about this, please let us know.
Yep.
Or search to see if you have any text messages that would be responsive to this request and let us know.
Yep. And we do see it from time to time. County commissioners are pretty commonly guilty of this. They'll say, no, I'm not doing it. It's my phone. Probably the county's not going to have you arrested to search your phone, but you are going to cost the county money if you do that.
Sorry, one more. Our vault is in a not temperature climate, and we've lost a lot of records due to the mold. So what would be a situation if that was the case, if we were asked and they no longer...
You identify the records that you can, and if they're illegible, then you just can't. That may be violating some other law, but it's not violating the Public Records Act. I think we're out of questions. We'll both be hanging around if y'all have anything you don't want to ask about in front of your bosses.
And also, if anyone needs the presentation, feel free to email the email you RSVP'd with, or if you need CCFO, CMFO, or utility credits, also send the email to the email that you RSVP'd with, and I'll get y'all certificates.
And final reminder, the flyers that are here are from the Secretary of State's office about the Safe at Home Address program. So if you're interested in learning more about that, grab one of those flyers.